So I wanted to talk about the possible value of legislative declarations in statutory interpretation cases. While textualists want to only focus on the actual text of the statute, the purpose of statutory interpretation, in my opinion, is to ascertain the intent of the legislature, which of course is charged with the lawmaking function pursuant to Article 4 of the state constitution. Now, while the judicial branch is charged with interpreting the law, how best should they interpret these laws? From my perspective, it's important to determine what the legislature was trying to accomplish, even when the language isn't entirely clear. So, how best can the judiciary do that? The courts, in my opinion, should consult legislative materials. Yes, there are, as I've often mentioned, shortcomings in those documents, but they should be consulted nonetheless by the judiciary. And those documents should include codified or uncodified legislative findings and declarations and legislative intent statements. Those findings and declarations are used by the legislature to provide explanation, justification, the basis for their legislative enactment. They're often fact-based statements, some even with citations to a study or other relevant data. They're often found in the first section of the bill, which may or may not be codified. Regardless, they are still part of the statutory enactment. And those findings and declarations are often followed by legislative intent statements. These statements are generally focused on expressions of the purpose or the desired outcome for the particular statutory enactment. And these statements, too, represent valuable insights into what the legislature was trying to accomplish when it enacted the particular statute. Now, additionally, because those provisions are part of the bill itself, as opposed to other legislative documents such as bill analyses, legislator statements, these can be attributed to the legislature as a whole, which is important to the courts. Now, I understand that the judiciary usually views these general statements of legislative intent to be of limited value to the courts. For example, I came across a written California appellate court decision that stated in part that legislative findings and statements of purpose in a statute's preamble can be illuminating if a statute is ambiguous, but a preamble is not binding in the interpretation of the statute. Moreover, the preamble may not overturn the statute's language. In other words, there first must be ambiguity in the statutory language in order for a court of this state to even refer to these intent statements. Now, assuming there is some ambiguity, the second problem is that these intent statements often do not shed light directly on how to properly interpret the ambiguous language. If these legislative statements are going to be utilized by the courts as an aid in construing a statute, then these statements should be directed at the actual statutory language. This leads me to the proposal. Include interpretive guidance in California legislative documents so that the courts do not have to try and use generalized intent statements to try and ascertain what ambiguous statutory language actually means or how it should be applied. So let me start with an example of the problem and how my proposed solution could actually work. Say, for example, there's a bill that's proposed to create a tax credit for hiring disadvantaged workers, and it might include an intent statement, such as it's the intent of the legislature to assist workers facing barriers to employment by offering a tax credit to businesses for hiring these types of individuals. Intent statements may also include some relevant statistics. For example, hiring opportunities are limited for disadvantaged workers such as ex-felons. The problem is that I've seen, we already know what the general intent is behind such a bill proposal, right? In other words, how helpful to a court or even an executive branch agency trying to interpret the statute or adopting regulations. I would suggest and probably agree with the judiciary that they're probably not of great value, which is why they are probably often ignored by the judiciary. A legal dispute, moreover, such as in my example, between a taxpayer and the tax agency, is not going to benefit really from those generalized statements of intent. And a court trying to resolve a dispute between the taxpayer and the tax agency isn't going to gain a lot or glean much from those intent statements either because they're too general. A legal dispute in a hypothetical tax credit that I'm using is going to be over, is the taxpayer entitled to claim the credit, right? Are they defined as part of the definition of who can claim the credit? Did the individual hired qualify for example, under a specified category of worker? Probably understanding why specific statutory language was or was not chosen isn't going to hinge on why the tax credit was created. Rather, the issue in this legal dispute is going to be whether the particular business was lawfully entitled to claim the credit or whether a particular worker qualified the business to claim the credit originally. So again, these generalized statements of intent probably don't assist a court of law in interpreting ambiguous language. So these generalized statements of intent really don't serve as an aid in interpreting the legislature's words. So what am I suggesting? Well, I think California legislation, such as in bill analyses, or perhaps in the legislation itself, could include interpretive guidance. So what does this actually mean? What would it look like? Well, for example, legislative committee analyses could include a sentence or two to explain some of the provisions of the bill when they're adding new code sections or amending an existing code section. And the idea behind this sentence or two would be to provide a brief explanation of what's intended with these new or changed provisions. For example, you could say, again, going back to my hypothetical, the legislature intends these types of specified businesses to qualify for the credit, but not these types of businesses. Or perhaps they could say the legislature considered including all felons as a qualifying category for this credit, but they decided that only felons convicted under these specific circumstances would qualify for this benefit. Yes, now I do recognize that this would require potentially lots more work for committee staff, and it would require the active engagement and discussion among the committee's legislators to determine whether or not these are appropriate and, in fact, proper statements of intent. But that could be accomplished, of course, in my opinion, with a sizable reduction in bill introductions and if legislative committees took on the role, again, hoping that they would have reduced bills to be considered, of reviewing and debating the proposed statutory language contained in these bills. So courts do consider legislative history when there's an ambiguous statute. But I think the legislature would do greater justice to the work if they could provide more robust historical information that could actually be viewed as useful by the judiciary. And of course, legislative history can take many different forms, and perhaps the courts might prioritize those different forms of legislative history and documentation.